All right, folks. Well, thank you again for joining us today. My name is Joe Hall. I'm the co-chair of Dorsey Whitney's Energy Industry Group. This is going to be our second panel for the afternoon. Today, for this panel, we're going to be focusing in on FERC and CFTC enforcement, what we've seen in 2015 and what we expect going into the rest of this year. I'm very excited because we have some great panelists joining me today. To my direct left is Tom Gorman. Tom is also, as anybody who was just watching the last panel, Tom is a partner with Dorsey in our Washington, D.C. office and is part of our government enforcement and investigations group. Tom and I work on FERC and CFTC and DOJ and general enforcement and compliance issues on a daily basis. Next to Tom, we have Sean Ledgerwood, who is a principal with the Brattle Group. Not to mention, Sean has spent a few years in FERC's enforcement program. And then finally, we have Nathan Plummer from KPMG. Nathan as well has some experience, quite a bit of experience on the regulation side and spent, I think, 10 years with the CFTC, Nathan? 9 years? Okay, I was close. So really we have three goals for today. First, we're going to give the crowd a quick update on what we saw at the end of 2015 and generally what we expect in 2016 at the FERC. Then we're going to give a similar update for the CFTC. In particular, we are going to talk about some recent enforcement cases involving agricultural commodities, which is somewhat new for the CFTC. And then, based on what we've seen at both the FERC and the CFTC, we believe that we're going to see another year of a lot of action on the enforcement side. And we're going to talk about what that means, particularly in light of some federal district court litigation that's pending, at least on the FERC side. From just a time management standpoint, you all may have the slide deck that has been circulated either electronically or in hard copy. We have quite a number of slides. Really, the goal for our discussion is to be more strategic. It's going to be more conceptual. So we're not going to get through all the slides. We're certainly not going to get through every bullet point, but they're certainly there for your records. And then if you have any questions about any of the slides or anything we say, of course, contact any of us. And, we're more than happy to do a one-on-one discussion. Or if you can't participate, for long or for the entire presentation, we're very happy to set up a one-on-one presentation with you and your company. So with that, let's jump right in and go to slide 19. And we're going to start with the latest and greatest out of FERC. And for those of you who may not follow the power, gas, or oil industries very closely, FERC is the regulatory agency here in Washington, D.C. that in effect has rate-making, enforcement, and reliability jurisdiction over wholesale sales of power and then wholesale sales of transmission, as well as the overall reliability of the bulk power system. Within FERC's organic statute, there has been some legislation that was proposed and accepted about 10 years ago, which significantly enhanced FERC's enforcement authority. And over the last 10 years, we've seen FERC taking full advantage of its new of the new statutory language, and it's spent a lot of time and money recruiting prosecutors as well as industry experts into its program to have a very robust enforcement procedure and process and group, actually. Just in terms of last year, to quantify what this means for the industry, what we've seen is as of November, early December, just in terms of civil penalties pending by virtue of civil and administrative litigation, FERC had nearly $545 million in penalties contingent on successful enforcement cases. There's another $42 million in money that will be contingent upon successful prosecution of disgorgement claims. Over the last 7 or 8 years, going back to 2008, we see evidence of a increasingly aggressive regulator. FERC has basically, by virtue of consent orders, settlements, or even litigation, assessed $628 million in penalties and about $300 million in disgorgement. So those are pretty eye-popping numbers. They quickly, they certainly get my attention, and they certainly have the attention of the industry. In terms of the politics here in the city, again, I'm not sure how closely you follow the agency, but we have a five-member commission. We are currently down one commissioner. Phil Mueller left over the summer and has joined the private sector. And then Commissioner Tony Clark, who's actually from North Dakota, has indicated that he will be leaving the commission at the end of his term. So we expect to lose him sometime between June and December. In terms of what that means for enforcement cases, that has yet to be seen. These cases tend to be somewhat agnostic. They're very, very fact-intensive. So there's certainly a political component to these things, and we're all curious to see what happens with the election and how these two slots may be filled. But just keep in mind that, in the same way the presidential election affects things like the Supreme Court, it will certainly affect what we do with the power, gas, and oil sectors. Moving on to slide 20. Just real quickly for the non-lawyer compliance managers out there, one thing I want to put on your long-term radar, I would urge you to look at FERC's most recent rulemaking concerning so-called connected entities in RM 1523, issued in September. For those of you who are familiar with the FERC has quite an extensive program in terms of monitoring sales, both wholesale power and transmission. And they also require public utilities and other regulated entities to file reports identifying who their different affiliates are for purposes of tracking market power. This rulemaking takes that one step further. What FERC is now asking to do through organized markets is to collect more detailed information, in effect put into a commoditized format, where they will be looking at things like shared employees, which would otherwise be tracked through interlocking director files. They are looking potentially, per the rulemaking, into relationships such as passive investors in wind farms, co-owners, even debt instruments. They are getting potentially into the details of contracts between different entities like asset management agreements and tolling agreements. As you can imagine, the rulemaking has resulted in quite a bit of public debate at the agency. We expect to see an order sometime in the spring, perhaps in the summer. If it goes forward as proposed, it will be quite a bit of additional work for your compliance programs. So again, we encourage you to track that proceeding if you're not. Moving on to slide 21 as well as slide 22. Just real quickly, as I mentioned, 2015 was a very active year with the FERC enforcement program. We've identified 4 show cause proceedings, 3 of which are currently pending in federal district court. I think these cases are going to be very, very important. The way it works on the power industry side, at least, is that a defendant has the ability to go to federal court. It is argued that a defendant has the ability to go to federal court to challenge a FERC-assessed penalty. These cases all involve significant penalties, at least for the size of the organizations involved. And we're not going to talk about Entracom because one of our colleagues here is actively involved in it. But we are going to come back to these proceedings later on in the presentation when we talk about concepts. In terms of federal district court litigation, the next 2 years are going to be very, very important, for the FERC bar. If you could just progress to slide 23. The cases I just laid out, 23, please. Okay. Are going to be very important because of this ability under the Federal Power Act to seek de novo review of a FERC order assessing a penalty. In effect, what is being litigated in the federal courts right now is whether or not an Article III court has the ability to do a full de novo review for a FERC enforcement order, or whether or not the judge really needs to rely on the record built by the FERC enforcement group as presented to the commission for an order. As you can imagine, the defendants in these cases are asking for a full Article III jury, with the right to depose witnesses, seek discovery, and make their case, perhaps in front of a jury. Tom and I, talk about this all the time, and we'll get back to, how this can impact enforcement strategy towards the end of the panel discussion. But of course, if you have the ability to challenge a FERC order in front of an Article III judge, that may play into your strategy as you're going through the Wells process at FERC. Other issues that are subject to federal district court litigation right now are whether or not specific individuals, and by that I mean managers, directors, traders, and now even more recently analysts, can be subject to penalties under the Federal Power Act if they are accused and found to have violated FERC's market manipulation rules. The statute of limitations issues are also being litigated, as well as a outstanding debate in the industry about FERC versus CFTC jurisdiction over physical markets and financial markets. So anyhow, I expect that the next 2 years will be very exciting for the Energy Bar. These cases are really going to be the beginning of setting up the framework that FERC's enforcement program will find itself prosecuting cases, and defendants find themselves defending cases over the next couple of years. And with that, let me turn it over to Nathan to go over kind of like the latest and greatest of the CFTC, with a particularly interesting case regarding Kraft and agricultural commodities.
Thanks, Joe. Similar to the large number monetarily of the fines that the FERC has issued in fiscal year 15, the CFTC also reported out for fiscal year 15 $3.144 billion in civil monetary penalties, of which I believe $2.8 million has actually been collected and deposited in Treasury. The bulk of that, of course, is from the benchmark cases, which include LIBOR, Forex, and ISDAFIX, and those matters all involve traders that were colluding to trade around certain benchmark prices that are used to set interest rates, foreign exchange rates, and ISDAFIX rate, which is a special rate that's used to price swaps. In addition to those cases,
can we move the slide to 24, please?
In addition to the benchmark cases, the 2015 was highlighted by the increased focus on what's known as spoofing, which is a type of disruptive trade practice. It was specifically identified and defined in the regulations following Dodd-Frank amendments in 2010, and has been used beginning in 2013, and then now in 2015 there were 3 new cases filed. One old case settled using the fraud statute as opposed to the new spoofing, but basically the same allegations. Spoofing, for those who may not know, is a term that means that a trader is putting trades on, either buying or selling, without any intent of executing on that. And that is considered a disruptive trade practice and is subject to civil monetary penalties and potentially felony charges, as we also saw this past year based on a case that was brought by the CFTC 2 years ago, the Cassia or Panther trading case, as many people will know. The spoofing cases brought this this year include one against a British citizen who the CFTC's claim is responsible in part for the flash crash of 2010. A new case called Oistocker and 3 Red, which involves this trading of crude, copper, and VIX contract, which is the Volatility Index. That case is pending in Chicago and is being litigated. Solemn and Kara, which are 2 traders, I believe, in the United Arab Emirates, involved in trading of gold and silver. And then the settlement that I had referred to was Mancado, which was had to do with wheat futures. What's interesting about the newer cases is that they really all involve algorithms that are used to put trades on electronically, and they are not visible to the human eye. They are on and off so quickly, no one could really see them except another algorithm, and that's really what the spoofing is all about in those matters. There's also, 2015 had also increased focus on reporting. The Marabini, the Topfer, and Welsh cases all were cases involving reporting. And when I talk about reporting, we're really referring to the various requirements that traders must comply with if they seek to hedge any of their futures contracts, and that's allowed if there is a bona fide hedging purpose, and the forms have to be filled out very detailed and specifically, and I think what the message to the market was in 2015 was that if you don't do this, there's going to be consequences, and that there were relatively significant fines given what the what the conduct was. As far as significant rulemakings to keep an eye on going forward, there's a new regulation called Reg AT that was promulgated in November of 2015, and AT stands for algorithmic trading. And what this regulation is in part a response to the spoofing, which I just discussed, as well as sort of the fear, at least by regulators in Congress in part, of the dangers of high-frequency trading, at least the perceived dangers. So what this regulation is going to require, if passed and made into, adopted by the Commission, is a new classification of registrants, which will mean that those businesses that are not otherwise registered with the Commission will now have to register if they are doing algorithmic trading as defined in the reg. And it's very detailed. I don't think this is the forum to really go through the details of that. But suffice it to say that this is a new regulation. It's going to require a lot of attention, and it's going to be significant imposition on traders, on FCMs, futures commission merchants, as well as swaps dealers and commodity pool operators and commodity trading advisors. So really it's going to run the gamut. It's going to impact everyone because of the broadness of the definition of what's algorithmic trading and algorithmic trading systems. The other rule to take a look at and to be aware of is the de minimis exception to swap registration, swap dealer registration. As it stands now, it's $8 billion, which means if the notional value in the 12-month period is $8 billion or less, then there's no need for that trader to be registered as a swaps dealer. That will be reduced to $3 billion as of December 31st, 2017, unless action is taken by the Commission before then. And I expect there'll be the comment period is formally closed, but that's an ongoing issue that's being discussed, I think, daily, and there's a lot of activity and interest surrounding it. The position limits for energy contracts has been on the docket for, it seems like years. I guess it is years. I suspect that will not be something that this commission will pass in this election year. I think in part the price of crude oil at recent historic lows has something to do with that, as well as just the fact that we are at the election year and the commission is it's comprised of less than a full staff at this point. Finally, the two key cases that are making its way through the court systems that I think may have interested to many are, first one is a case known as CFTC versus Kraft. This is a case that was brought by the commission against Kraft and Mondelez, its I guess successor in interest, having to do with some wheat trading that was done, I believe it was in December of 2011. Kraft is a major, at least at that time, was a major buyer and user of wheat for its brands, crackers and cookies and things. And one of the things that was happening in the fall into the winter of 2011 was there was an increase in the cash price of wheat. And there was some momentum and decision-making, and at least alleged in the complaint, that internally at Kraft on how do we reduce the costs, and there was some suggestion and some correspondence, as alleged in the complaint, that one of the things that may be helpful is to maybe get more active in the futures market. And what was alleged in the complaint in this case is that when Kraft got more active in the futures markets, they didn't really have any intent of ever taking delivery of the wheat that they're buying these futures contracts for, because of various logistical reasons and quality reasons. They do better off in the cash market historically. The complaint alleged that Kraft did this solely to reduce the cash price available to it, as well as increase the futures price on which they would ultimately be able to sell the futures positions. That case was subject to a motion to dismiss that was filed by Kraft and Mondelez. That motion to dismiss was denied. Essentially, the court had held in that case that the new regulation 180.1, which is a variation of the manipulation standard, which is based on the SEC 10b-5 standard, only required that a fraudulent artifice or device be alleged to support a claim for manipulation, and there was no need to do the four-part classic manipulation test that has existed historically under the Commodity Exchange Act. There was back and forth arguments, but what's key to understand that the takeaway from this case is that this conduct, there was no allegation that there was really any traditional fraud as we think of it, but it's more of this fraud on the market concept, which was according to the court sufficient to state a claim upon which relief can be granted and survive a motion to dismiss. And in that case, they're just saying all the different evidence that was alleged in the complaint was that, that Kraft intended to do these trades. They had no intent of taking delivery, which seems to be just speculative trading, which many traders do in the marketplace. But in this case, because of, I think, the size of the open interest, and there were certain days in which the position limits were exceeded in December of 2011, that all of those facts, as alleged, were sufficient to at least get to the next stage and let discovery to proceed on that. And I think there'll be continued interest.
So what do we think about this case, guys? I mean...
Well, I was just going to say, what do you think the fraud was? What did they do?
Well, that's what most people don't really understand.
Yeah.
I mean, I think...
Including Kraft.
Yeah. I mean, it's it's interesting because there's a lot of chatter on what they were intending to do, and the question is there something about that fraudulent or illegal? And that's where the commission and the defendant disagree, I suppose.
So there are a lot of facts in the case, though, that would suggest that Kraft never intended to take delivery of the wheat. So the wheat was of substandard quality. The wheat was to be delivered down the Mississippi so that the transportation costs would have been prohibitive, that they didn't have storage available to store the amount of wheat that they were buying. And so that, therefore, the only reason that they were buying the wheat was to pump up the price to benefit either their spot purchases, driving that price lower, or to benefit their calendar spreads, which benefited from a higher December price. And so that's the essence of fraud, that they execute these trades not because in any way, shape, or form that they needed the underlying commodity. It was only to create these other ancillary effects.
But in those markets, this is what, number 5, red wheat. Okay, it's a traditional commodity market. People get in those markets all the time. They don't take delivery. They just flatten the contracts out. They close them out. They put on spreads. Sometimes they make money. Sometimes they don't make money. So that's not fraudulent. So what's fraudulent here?
Yeah, well, I think that historically what Kraft had done is they would go into the futures market to hedge the price of their cash positions. So it would be, and they would flatten those longs out as they were buying cash positions. In this case, the complaint alleges that there was $93 million worth of wheat, and they ended up only taking, they only had the capacity to take about, I don't know,
Fraction.
Yeah, fractionally,
Really
5 million, and that's all they had storage capacity. So that it was clear on its face that there was never any intent to actually take that. But one could argue, I mean, that's how a lot of trading that takes place in just about every futures market, that many, if not most of the trading that goes on in our futures markets has nothing to do with any intent to take delivery. It's used as risk management, or it can be used in perfectly legal speculative trading. So, and I think, that's sort of the friction here, and I think that's what's so alarming to many when they see this and they're saying, what is really illegal? What is it that we can take away from this action? How do we advise our clients going forward? What are the do's and don'ts in their trading programs?
Yeah, I think a lot of people who read Kraft see an intent-driven standard. You intended to do this, you intended to do this, and you intended to do that. But thinking about stuff isn't fraud. You can think about stuff all day. If you move it into the securities market, which is where that statute came from, I can think about manipulating that stock, but it doesn't make it so. And I can think about taking delivery or not taking delivery, and then you can make it so. And the CFTC has sued people for taking delivery. Years ago in the silver markets, when the Hunts took big positions on, and they took delivery. And I sued them on behalf of the government of Peru and won, but their defense was, it's a delivery market. Why can't we take delivery? And we said, well, because you lied. And when we proved they lied, they lost. But the commission then said, well, you were going to take delivery. That's bad. And they brought an enforcement action. So it's the flip of Kraft.
Yeah.
Can you talk about the scale a little bit more? Because 90% of futures contracts settle without delivery because people are going to buy, say, spot commodity. They're just doing a financial hedge. And, so it's 90% of the time, roughly, you don't expect delivery.
Right.
But didn't this have to do with the scale being so much larger than the physically spot they were likely to hedge?
Yeah, I think, I believe it's alleged somewhere that it may have been over 85% of open interest on at least one or more of the days. And I think that may have been sort of the red light that went off at the commission. I'm sure that the DMO or someone identified this. I suspect, I don't know. And that's how this whole thing started. And those are the kinds of alarms that do alert regulators historically.
the other element that's present in this case and seems to be present in most manipulation cases is that there's, at least there's been asserted that there's lots of documentary evidence that was circulating amongst folks saying, hey, the intent of this is to drive down the spot price to benefit our other positions, or the intent of this is to drive up the futures price to benefit our spreads. And so one of the easiest things that you can set up for a regulator is to have documentary evidence of intent not to be executing the trades for a standalone legitimate business purpose, but instead to be executing the trades to benefit other positions that are tied to whatever price or volume or whatever it is that you're trying to screw with.
Right. I think that's a good point, but at the end of the day, I don't think you can have an intent-driven standard. You've got to do something. Now, one thing that I thought was interesting in Kraft that nobody seems to talk about too much is there's a position limit claim against them also. They violate the position limits. If they were representing to the market that the positions were a legitimate hedge when they weren't, that would deceive the market. And then you could violate, then I would think you could violate the statute. But nobody seems to have developed that. It just sort of floats through the case that there's a position limit problem, but nobody really does a whole lot with it.
Doesn't the Commission seem to be taking the position that under 180.1 intent isn't necessarily required? They're taking an outsized position as compared to the rest of the market and putting yourself way ahead of everyone else in and of itself could be a deceptive device that violates 180.1.
I think in part that's right, but they argued that in the briefing on the motion to dismiss that they were under the more relaxed 10b-5 of recklessness. So they're saying that everything that is put forth in the complaint as far as what was going on in the minds of the business that was doing the trading would at least indicate recklessness of behavior, that they wanted to do something and this is how they went about doing it. And I guess the argument is that it was reckless conduct because it clearly had an impact on the pricing of the futures as well as on the cash market.
Do we think that this is evidence of an increased focus on agricultural commodities over the next few years? I mean, we've seen an uptick in ag cases coming out of the CFTC. What do you all think?
Yeah, I mean, I think that the Commission will focus on things that are brought to its attention that in their view is serious. Traditional commodities have not been as volatile as the energy markets and certainly interest rates. So it's taken less focus from both the DMO staff and enforcement. I think what we've seen in recent time is commodity prices of all commodities have become more volatile. So yeah, I expect there will be, and I think that's part of why Marabini came out and Topler, because those were really major companies that just, I think that it was more, they didn't know how to file Form 204 because there had never been focus on it traditionally. And now that under the folks in DMO now, they're looking at them and they're making referrals to enforcement, and I expect that to continue.
But this is a traditional area of enforcement for the CFTC too. They've always had the ag markets.
Right.
Energy's just been sexier lately, but they also have a very limited staff and they have a very limited budget. I think they're the only federal regulatory agency I've ever seen put in a press release when they settle the case. They say there are individuals who are responsible here, but we don't have the budget to go sue them.
No, that's very telling.
Yeah. And I've seen at least two of those.
Yeah.
And that's just, and I wouldn't hold my breath. They're going to get any more money now.
And let's move, for those of you who are following via the internet, move to slide 34, which lays out some recent agricultural commodities cases from the CFTC. I mean, Nathan, is it worth going through Kent Woods or Ulm International very quickly, just to keep them on the radar map of people?
Yeah, I mean, I referred to these in some detail already, but just to recap, I mean, Marabini was a large Japanese or U.S. subsidiary of a Japanese company that for years and years and years have been filing Form 204s, these are documents that sets forth the cash positions, which are used as a basis for exceeding position limits, so that this is what they want to, as a risk management device, they want to be able to go through whatever the position limit is under Reg 150.1, I believe. What Marabini did for at least 38 occasions was filed the Form 204s that included contracts subject to hedging to include cash and basis positions. Now, basis positions cannot be used as a basis for hedging because basis positions, by definition, are already self-hedging. In other words, the price of the commodity in a basis contract is tied to an index. So it already hedges itself. So Marabini didn't seem to understand the difference between the two, and that's how they reported it. Not listed there is Topher, which is a very similar case. Interestingly, it was charged with doing the same thing and was fined $400,000 as opposed to $800,000. But there is quite a bit of information in the press release on that as to the level of cooperation that Topher exhibited in, I guess, the investigation. And that, I think, may also be a message to the marketplace that self-report if you can, and cooperate, please. I think that's really the takeaway from that. And Olam was the case involving position limits on the cocoa futures, and it's claimed that there was non-competitive tradings, and that was a $3 million penalty. Just another commodity, agricultural commodity case. And then the Kent Woods had to do with basically after the fact doctoring of records to sort of hide violation of rules, and that was involving a wheat trading operation, and in that there was a $200,000 penalty against an individual, $500,000 against the company, and there are various trading bans going forward in the wheat market. I think it was a 5-year trading ban.
Well, that's quite a lot.
Yeah.
No, and again, I think it's evidence that the CFTC, particularly in this industry, is getting, this being the agricultural industry, is getting increasingly more aggressive. Let's do this. For those of you following up via the internet, let's move to slide 36. And, let's step back and have more of a conceptual conversation and really think about, what it means to get served with a subpoena and what it means to really defend yourself against an aggressive regulator. When you're dealing with what the CFTC and the FERC have, in terms of market manipulation, a fraud-based statute, where basically you have, 3 things that need to be proven, essentially. A device that is used to, take an action, a deceptive intent, in legal jargon called scienter, and then some type of involvement with a FERC or CFTC jurisdictional activity. Just for the non-lawyers who are dialing in, really, it's almost like what you see on TV, moving the slides 37 and 38. When these guys come knocking, they'll look for evidence of intent. So they'll look for emails and IMs when you trade power or FERC products, for physical products and financial products. You need to save documents for 5 years. So of course, the regulator will ask for emails, memos, instant messages. To the extent you find yourself in trial or under an investigation, they can depose a witness. They can cross-examine you to the extent there's a trial. What I've seen more and more of at FERC are actually people ratting each other out, whether it's companies or individuals. And there's certainly been a few FERC dockets over the last year or two where business partners have ratted each other out to actually, that's a strong statement, where business partners have provided evidence that perhaps would indicate that arguably another partner hadn't provided documents that the agency had requested. So it's a real case. And going back and moving the slide, 40 here. You have to start asking yourselves questions. I mean, are the FERC and the CFTC, are they getting overly aggressive? Or are they overplaying their hands? I mean, do we have an issue here of over-enforcement versus effective enforcement? So I thought what we would do to kind of tee up this conversation is I'm going to turn it over to Sean for a couple minutes, and he's going to go through some concepts, and then we're going to talk about how these concepts, as prosecuted in the context of a FERC case or a CFTC case, are matching up with SEC case law, and then all the things you should be thinking about when you're defending yourself in an investigation.
Okay. Thanks, Joe. So just very quickly, the main question here that I keep hearing as a recurrent theme, and this is true of the first panel as well as this panel, is the essence of fraud. The fact is that the FERC's anti-manipulation statute, as well as now post-Dodd-Frank, the CFTC's anti-manipulation statute 180.1, are all based on this 10b-5 concept of fraud. The FERC has been very aggressive in how it interprets what is fraudulent behavior. And I've put some thought into this and some analysis through this thing that I refer to as the framework. I'm really not going to talk about that here right now. What I want to focus on is the basic idea of how do we define fraudulent behavior? How do the agencies think of fraudulent behavior? Is it possible to push that envelope too far in terms of thinking what's fraudulent or what is not? One of the things I often hear from people that are involved in manipulation cases is, hey, we aren't violating any market rules. We're not violating position limits. We're not violating our tariff in the case of FERC practice. How could we possibly be violating the anti-manipulation rules? The reason is because of this concept of fraud. You can be doing things that individually all abide by the tariff, yet collectively violate the anti-manipulation rule. For example, if I'm trading in a way that's intentionally losing money, there's nothing wrong with that on a standalone basis, but maybe I'm just stupid. If I'm doing that and it's moving a price, the fact is that's kind of the effect of any sort of purchase or sale. Sales tend to lower prices, purchases tend to raise them. I may also have a speculative position on the side that's tied to that price. If I put all three of those things together and that intentional loss is moving a price to benefit the value of my much larger financial position, that's a market manipulation as FERC is interpreted under its rules, rightfully so. Next slide, please. So when we think about this from the standpoint of market manipulation, there is obviously a need to deter manipulation. Manipulation creates a lot of problems in the marketplace. It disrupts efficient price discovery. It results in redistributions of wealth. And in electricity markets and in any sort of capital-intensive industry as well, it can distort incentives in the long run to make people invest or not invest in an inefficient way. For example, if you continually suppress prices in the capacity market, people aren't going to want to build new capacity. In the long run, that's going to wind up having reliability implications. So manipulation is something that should be deterred. The question is, how much? The fact is, if you over-deter manipulation, you are also going to simultaneously deter a lot of legitimate trading, which is necessary, in fact, to deter manipulation. One of the things that deters manipulation is lots and lots of activity in the marketplace. In that event, if somebody puts fraudulent trades into the market, uneconomic trades into the market, they have very little impact because liquidity has been maximized. So the idea is that there's this optimal amount of enforcement. The optimal amount is going to deter manipulative behavior while encouraging legitimate behavior. Where is that dividing line? Obviously, that's very hard to know. Next slide, please. So what I'd like to talk about is the idea of where the agencies have gone thus far. FERC has taken the approach that they are not going to say what manipulation is or what legitimate activity is. They're going to have a series of settlements that are going to come down, and people are going to read the settlements. They're going to see the types of behavior that have been manifested and that the FERC has gone after. And they're going to say, hey, I get it. I understand what is manipulative. To a lesser extent, by seeing these settlements over time, they should also be able to figure out what legitimate behavior might be. There are two types of behavior that the FERC has prosecuted under its fraud-based anti-manipulation rule. Outright fraud. So, for example, in the demand response cases, alleged setting of benchmarks, load response benchmarks at artificial levels. Or uneconomic behavior. Somebody going into the marketplace and flooding the volume full of either excess supply, excess demand, in an attempt to push the price down or up, respectively. The fact of the matter is, the cases that have been prosecuted thus far you can look at the alleged behavior and tell yourself, hey, is this the type of behavior that should be encouraged in the marketplace? And time again, you'll say, no, this is inefficient behavior. For example, as alleged in J.P. Morgan, you had power plants that were being bid into the marketplace at minus $30, essentially as price takers. These were old power plants, never had any right to be dispatched in merit, as alleged, but yet they were put online. Why? So that they could command out-of-market payments, whether either through exceptional dispatch or something else. Keyspan Ravenswood, you had withholding it from the capacity market. Why? Because allegedly there's a swap on the side that benefited from that withholding. Again, not something that should be encouraged. Rumford Paper, again, allegations of falsely setting a demand response baseline in order to receive demand response payments when, in fact, as alleged, there was no load to actually cut. If you look at these types of cases, you say, okay, we get this. There's inefficiency there. Consistent enforcement over time, trying to prevent this type of behavior, we get. Next slide, please. The problem is that the FERC has not necessarily given signals to the marketplace that it is only going to prosecute cases where such inefficiency is manifest. I'm citing in this slide some language from Deutsche Bank that in essence says profitability of the underlying transactions is not necessarily a defense to market manipulation. In other words, the fact that you tried to place a trade and maybe you did not make as much money on that trade or you lost money on that trade, even if you made some money, we're not going to necessarily hold that to be proof that you weren't trying to manipulate the market. There's two ways to view this perception. One would be consistent with the allegations of the BP case that just came down at the FERC, where the FERC is essentially saying, we are judging your profits on the basis of opportunity costs. If you made $3 on the trade, but you could have made $5 on the trade somewhere else, and yet you repeatedly chose to make $3, we're going to call that an uneconomic decision because you willingly gave up an additional $2 of profit somewhere else. As an economist, at least, that sort of makes sense. It makes sense that you are giving something up, you are losing profits in order to make those trades occur. That's one interpretation. The second interpretation is a little more distressing. The idea that the profit or loss that you make on a trade is totally irrelevant. All that matters is your bad intent. And this gets into the issue of Kraft. This gets into the issue of fraud that's so concerning for our clients. If there is some bad intent, some bad idea, that you place this trade with the idea that it could possibly influence something else in your portfolio, by gosh, that's market manipulation. That second presumption, that second way of viewing the universe is highly problematic. I call this a PerSe rule, where essentially it is the intent that is manifested between two positions that's viewed as being manipulative. Doesn't really matter if you also had a legitimate purpose behind the trades. Next slide, please. So, I don't know if y'all ever recall the little Johnny jokes. Johnny was always the bad little kid in class that got in trouble for doing stuff. So I'm going to give you an example using Jack, Jill, and Johnny. Jack is considering a power trade. He's going to flow power from A to B. If Jack makes the trade, he makes $10,000. Jack has nothing on the side that could possibly benefit from this. Jack executes the trade. Can Jack be found guilty of manipulation? Of course not. First off, there's nothing to manipulate because there's no position on the side. But secondly, we look at that trade and say, you know what? That's what traders are supposed to do. Traders are supposed to create value by moving resources from people who value it less to people who value it more, and they can make a profit as a result. That's an efficient trade. Go Jack. Jill is considering the same trade. But Jill has a huge FTR position on the side or some other financial swap that's going to be benefited greatly by this A to B $10,000 profit-creating trade. But Jill has no idea that that other position exists because it's on the other side of the wall. Jill may be trading for the corporation, and in fact, this is something that's a speculative position held for some client. Jill executes that same A to B trade. The fact is, Jill can't be prosecuted for market manipulation either because she has no idea that this other position exists. She has no intent to manipulate. Go Jill. She can execute this A to B trade, no problem. Johnny is considering this same A to B trade. Johnny is the person that put that huge FTR position in place. Johnny has an email chain where he's bragging to all of his friends, wow, I'm going to be able to execute this A to B trade. I'm going to massively increase the size of my financial position. And oh yeah, I'm going to make $10,000 to boot. The fact is, Johnny could be prosecuted for market manipulation under a per se rule, because Johnny's intent in placing this A to B trade is not necessarily to make money on the A to B trade, it's to make money on this other position. You see there that there's this weird balancing question of, it's kind of like how much is too much evil intent? Next slide, please. The fact is, there's a question. Yeah.
So if the A to B trade would result in Johnny making the same amount on the trade as he did on the other position he had, then he could argue, hey, that's not a bad intent because I didn't benefit any more here than I did there.
So the way I would characterize it is just a little differently. Okay, Johnny is going to look at this trade on a standalone basis and ask the question, should I make this trade? And Johnny would look at that trade and say, yes, I should. As a matter of fact, any market participant would look at that A to B trade and say, you know what, there's $10,000 to be made there. I should go make that money. The thing that separates Johnny from any other market participant is that Johnny has this other position on the side that will benefit from it. My question to you, to the audience, and to the question of what over-enforcement is, the fact is that same A to B trade is going to be profit maximizing and is going to be efficiency enhancing to the marketplace, whether it's placed by Jack, Jill, or Johnny. More importantly, I think this is getting closer to your question, it doesn't matter who makes that A to B trade. The same benefit accrues to Johnny's financial position. Everybody's worried about Johnny making this trade because he's trying to pump up the value of this financial swap. The fact is, if Jack made that trade, the same benefit would accrue. If Jill made the trade, the same benefit would accrue. I would contend, from an economist perspective, that it is absolutely ludicrous to allow one market participant to make an efficient A to B trade when another cannot. That, to me, is the problem with a per se enforcement paradigm, and that is what I'm concerned about in terms of this potential for over-enforcement by the FERC, by the CFTC, and by other agencies. Did that answer your question, sir?
Not quite, because in that situation you just described, if X makes a trade based on market analysis, then it's fine. If Y makes that exact same trade based on the possession of inside information, that's a problem.
Right.
So that's the exact same trade, the exact same economic effect, but because this person was in possession of information that he's not supposed to have, he can be prosecuted for that trade. So I don't think that's the analogy. What I'm thinking about is more, even though it would be economically favorable to Johnny to make a $10,000 trade, if he thinks this through, as you have, that maybe that makes him vulnerable to a manipulation charge, shouldn't he, as a to be proactive, make the trade of the same, assuming he has the financial resources to do it, make sure that his benefit is equal or greater than the one in the other position?
Yeah, when we get into the idea of some of the stuff that I've published about the manipulation framework, we get into the concept of leverage and the idea that if I'm executing a trade and I lose $1 million and I make back $500,000 on my quote-unquote manipulation target, the fact is that target has a name. It's called a hedge. And it's a perfectly legitimate use of whatever that financial position is. If I lose $1 million, I make back $1 million. Well, then it's a perfect hedge. And again, it's a perfectly legitimate use. When that amount of leverage increases from 1 to 1 to, say, 5 to 1, where I lose $1 million, make $5 million, now it looks more like a manipulation. Now it's a manipulation concern. So from the standpoint of differentiating between legitimate versus manipulative behavior, that type of analysis is certainly relevant. Here I'm more concerned with the intent behind that behavior that, quote-unquote, triggers the manipulation.
Right. And actually, Sean, on that note, it's a perfect segue. So let's talk about what we've seen over the last couple of years in terms of potential over-enforcement versus effective enforcement. Now that we're seeing these cases go to federal court, let's say that you don't have smoking gun evidence of intent. You don't have an email, right, or a memo or an IM. How do you actually prove these cases? I mean, if you are the CFTC or the FERC or even Justice or anybody else, I mean, how do you actually make your case without the smoking gun documents?
Well, one of the things that the regulators do, I mean, and you started with it, Joe, and actually let's go back to something Sean said. They're not going to define manipulation for you. There are people who argue that they should. They won't. And they won't for an obvious reason. If they do, people will figure a way to go around it. So the statute says what it says, but it has elements, and there are elements in it that you have to prove, and one of the tensions in all of these cases is, what are those elements? Intent is nice, but that's just thinking. That's not fraud. Making money is not fraud. If you make money on the trades, they'll say, well, that doesn't insulate you from manipulation, as Sean said. If you lose money, they'll charge you with an attempt. So you can make money and you get charged with fraud, or you can lose money and you can get charged with attempted fraud. It's the same statute and it's the same penalties, so you wind up in the same boat. So the question really is what's happening in the marketplace, and what the regulators do is the first thing that happens is you get a subpoena that says, I'd like every document in your place, please, and send it by tomorrow. And so you send them all this stuff, and they read all the emails, and sometimes they find some stuff that's suggestive. But more appropriately, what they really have to do is they have to take your positions and build themselves out a pattern and see what you did. Right. So in Kraft, if you've got on big, long positions in wheat, they'll take a look at that and they'll see what you're doing. Kraft probably had some other positions. Maybe they had some spread positions on there, and they'll take a look. Or maybe they're trading in a different market. Maybe they're trading also in the spot market, which a lot of these cases are. And they will chart these things out, and then they'll try to take a look, and they'll see, okay, you've got this position over in this market. You've got this position over in this market. What's the intersection, which is what Sean was talking about? What's the economics of this? Okay, this position pushed the price over here, which is what Kraft is. That's all Kraft is really about. They use the futures markets to push the spot market price. And then the question becomes, is that fraud? Yeah. And that's the ground level in that case. Moving the price isn't really fraud. Every time you buy stock, commodities, futures, physicals, it has an impact on the price. That's not fraud. So the real question for the regulator is, how do I prove fraud? And they like to back it up into intent by saying, you did this pattern, you did this pattern, you did this pattern, and it moved the price, and that's uneconomic, and that's bad for the industry, and it's bad for these guys, and it's bad for those guys. But you know what? As a trader, I'm not there to protect the industry. That's not my job. I'm only there to trade. I'm only there to make money. For me, if I don't lie to somebody, if I don't deceive them, if I don't trick them somehow, then I don't see that it's fraud. But what the regulators like to lay out these patterns and argue the economics, and that's one of the arguments that's going on in Kraft.
I mean, if you read these cases, I mean, the show cause orders come out years after the activity, right? And the investigations begin, maybe a year, after, whatever the transaction is. I mean, is it even reasonable to go back and look at a trade with 20/20 hindsight? I mean, what if it's just a bad trader? What if it's just, it's just, they're not very good at what they do, and perhaps that's recklessness, but how do you, again, pulling the smoking gun document out of this, how do you really prosecute this and then defend it?
I think that, what Tom was saying, at the end of the day, it's an economic analysis, and that's how regulators would approach those cases where there aren't smoking guns, is they look at how did this trader or this company historically trade in this specific contract? Is there some aberration here? What else could possibly be motivating it? What are the off-exchange positions? You just go through it all because it's always the same analysis. And if they see outliers there that can't be explained in any other way, then they may bring an attempt and maybe it perfected depending on what happened. And and the one case we didn't talk about is the Wilson DRW case. it's an interesting case because it highlights under the traditional 982 manipulation of the Commodity Exchange Act, the CFTC's view that on an attempted manipulation case,
Right.
that the CFTC's position is that it only has to prove that there was an attempt to affect price. And they said, they're arguing, and it's on summary judgment now, there's no requirement that it has to attempt to make an artificial price. So they make that distinction. One could argue every trade is affecting
No,
price.
that's
what Thomas is saying.
That's exactly right.
It makes it a much easier burden for them.
No, that's exactly which takes me to my next point. So, all right. I mean, for those of you who don't know, traditionally, regulatory litigation before an administrative law judge doesn't really tend to be subject to the rules of evidence, okay? So let's say you now are prosecuting something that came out of the CFTC or FERC or even the SEC in federal court. I mean, I think the SEC tried to push cases back to the ALJs. I think, with at least FERC, you're seeing people trying to push things to federal court. What would be the difference then in the ability to defend a case in an Article III court versus the ALJ?
Well, there's a significant difference, and that's what we started to get to at the end of the securities panel. There's a loud outcry at the SEC, which is emblematic of all of this stuff. They're pushing all the cases in-house. There's no discovery.
Yeah.
So the staff spends 2 years, 3 years, 4 years, however many years they want, gathering all the evidence, and then they've taken everybody's testimony, and then there's a rush to judgment of let's put this all on, and you as a defendant have no ability to take the depositions. You're getting dump trucked a lot of times with their evidence. It could be millions of pages of stuff. And then, by the way, there's no rules of evidence either. Right. So if we're having double and triple hearsay and the ALJ wants to let it in it comes. You want to put in, sworn affidavits that you can't cross-examine, it comes right in. And it's very difficult to defend that kind of stuff.
It's extraordinarily difficult.
Yeah, that's why you want to be in federal court.
So, and one final point before we wrap up here, but, I mean, so you are a regulator doing a Article III trial. I mean, what are we seeing out there in terms of where they're overplaying a card? I mean, misrepresenting a fact. Well, first and foremost, how do you present a detailed economic argument to a jury? One, right? And then, do you lose credibility when you are the government and you overplay a fact or you overplay an argument? How does that hurt them, if at all?
If you're doing it to a jury, it has a huge impact. In an administrative proceeding, the government tends to just sort of dump their evidence in. Judge, here's a whole pile of stuff. It's in there someplace. Go find it. I'll write you a brief. And that's what that looks like a lot of times. But in federal court, the judge isn't going to do that. And you can't do that to the jury, which is why it's more difficult for them to present that stuff. You can present complex economic testimony like Sean's talking about. You just have to present it right. A lot of people don't understand what they're presenting, so you really have to take the time to put it in. And then you've got better standards too, because you can argue the law to the judge as opposed to you're arguing to an ALJ who's already been told what the law is by the commission, and the commission may have a different view of that statute. They may not think that you have to prove marketplace deception and artificial price and all of these other things. They may think that intent is enough. Well, if they do, then you're just trying the case to an ALJ who's already stuck, and you can appeal it to the commission, and you're stuck with the same law, and then you can take it to a federal circuit court, and the agency will come in and say, oh, yeah, you have a hearing there, but guess what? Chevron deference. So the agency wins.
Yeah. Yeah, no, which going back to where we started, which is why I think these cases that are starting to run up to the federal courts, at least on the FERC side, are going to be so critical for laying out what the next couple years of enforcement look like. One final point. I mean, ultimately, if you know that you have a right to a jury trial in Article III court, I mean, that could really impact, the way you communicate with the regulator during, FERC's equivalent of the Welch process.
Yeah,
I mean, assuming you even want to go with it, which may be a consideration.
That's exactly right. Yeah. If you're really looking at the case and you say, I'd like to contest this, but I'm stuck in the administrative process, and this is the way the commission's interpreted the law, and it's not good for my defense, you may decide to settle.
Yeah.
But if you can take it out to a circuit court, a federal district court, you may decide that you want to litigate the case and challenge them and raise these issues. So this forum selection stuff is really critical to what you're going to do.
Yeah, absolutely. Well, folks, thank you very much. We've run out of time for today. Again, we went through a lot of material today. If anybody present physically or dialing in has any questions, please feel free to reach out to any of us. And like I said, if there's a scheduling conflict, please let us know. And I think we'd be willing to do a one-on-one session with you over sandwiches or lunch or something like that. So thank you again, and we'll move the third panel.